Hello learners, I welcome you all to the 12th week of this course on International Investment Law and the Environment. I know this is the last week of the course. We've been discussing about various ways in which we can reconcile environmental principles within the field of international investment law. For the past 2 weeks, we've been discussing about the role of applicable law. We've been discussing about principle of systemic integration. We've been discussing about a standard of review. We've been discussing about the proportionality analysis, principle of good faith, amicus curiae submission, transparency in investment disputes where an environmental regulatory measure has been challenged. So there are various ways in which environmental principles can be reconciled within the field of international investment law. So, sort of following through what we've been discussing in the past 2 weeks, we are going to discuss about exploring other alternatives where an investment dispute that involves an environmental regulatory measure can be considered or looked at or decided. So, one such suggestion that we would be making in the 12th week is mediation can be explored as an option in order to resolve the dispute between investor and the host state that involves an environmental regulatory measure. So, for this purpose, I have decided we will have 3 lectures which will discuss about essentially mediating investment disputes which involves an environmental regulatory measure. So, what is the structure of these 3 lectures? So, lecture number 55 will explain you what the concept of mediation is. I am not going to presume that all the learners are well versed with the idea of what mediation is. So, if I have to make a concrete suggestion that mediation can be a better suited mechanism for resolving investment dispute that involves an environmental measure, I feel it is necessary that we all should have a good conceptual understanding of the mediation process itself. That is precisely the reason why lecture number 55 exclusively focuses on what mediation is. Then we will move on to lecture number 56, which will talk about mediation as a dispute resolution method in ISDS itself. Then finally, in lecture number 57, we will be looking at how mediation can be a useful process for resolving disputes between the investor and the host state with regard to an environmental regulatory measure. So, these are the 3 ways in which we will look at the concept of mediation. Then moving on, we will discuss other mechanism like introducing appellate mechanism and having some sort of having some sort of a permanent multilateral permanent code, which is sort of a suggestion or proposal by the European Union. So, all of these we will discuss subsequently in the subsequent lectures. And who can better discuss the concept of mediation than the teacher who teaches mediation law at NALSA. So, I have invited a subject matter expert, Dr. Kapil Sharma, to explain the concept of mediation. So, without further ado, let us hear from him. Thank you.
Hello learners, I am Dr. Kapil Sharma. I'll be discussing mediation. As we know that disputes are an inevitable part of life. In order to resolve them, there exist various methods, and these methods can be broadly classified into 2 categories. The first category is known as adversarial method and the other category is known as consensual method. Under adversarial category, you have tools like litigation, arbitration, expert determination, which are used to resolve the dispute. Under consensual method, the tools are like your mediation and conciliation. Now, in adversarial method, what happens is parties, they present arguments, they present evidence, they show their legal positions. Based upon that, the disputes are resolved, and the disputes are resolved by a neutral person who is known as judge, and he gives the judgment in favor of either of the party. So, end of the day, you will going to see under adversarial system, one party wins, other party loses. But if we see consensual system, the importance of consensual system is that you don't have to show arguments over there, you don't have to show the evidences over there. It's a collaborative process. Based upon that, the dispute is resolved, and end of the day, you will going to see both the parties are at win-win situation. So in this particular session, we would be discussing mediation, which is a consensual mode of dispute resolution. Now, what is mediation? There are various definitions of mediation, but one of the very simplistic definition of mediation is this is a voluntary process where a neutral person who is known as mediator resolves the dispute. Now, if we look into certain essentials of mediation, the first essential is it's a voluntary process. It should be coming to your mind that why you should go for mediation, because this type of flexibility is not there in litigation. So in mediation, you decides on your own that, okay, this is a particular dispute suitable for mediation. And how you decide this on your own, the way is that whenever you enter into a contract, you put a clause over there that if any dispute occurs, it would be resolved through mediation or conciliation. So this is a voluntary process. Apart from that, the one very essential of this entire process of mediation is this is a party-centric process. You are at the core of the dispute. The mediator tries to facilitate your concerns. Based upon that, the dispute would be resolved. And when we talk about the comparison between these two types of method of dispute resolution, which is known as litigation versus your mediation, remember this thing that litigation is a structured process. You don't have flexibility over there, but whenever we are talking about mediation, one of the biggest advantage of mediation is this is a very flexible process. Okay, but flexibility doesn't mean over here that there are no stages. There are certain stages involved over here. Based upon that, you resolve your dispute, but these stages are very flexible in nature. The other essential, which is required and which is the core based upon which you resolve your dispute, is a negotiation process. You must be wondering that what happens in mediation. It's not like that the two parties coming together on the table, they are discussing their issues. Okay, if this was possible, they could have done earlier. Now, in this process of mediation, they require the help of a trainer. The trainer over here is known as mediator. He's a certified person having a specific technique to resolve the dispute. With the help of this person who is known as mediator, you negotiate. Whenever you are not able to find a solution through negotiation, your mediator intervene, and based upon that, you again start the communication, which is also known as negotiation. So this process of negotiation with the help of mediator is a very core process of resolving this dispute. Apart from that, this is a confidential process. Sometimes you must be wondering that when we go for litigation, there are so many persons are sitting in that room. You might not be in a position to share the confidential information over there, because you know, end of the day, whatever you will going to share the information, that's not confidential. But in mediation, in the very beginning when this process has been started, this information is dedicated as a confidential information, and the mediator throughout the process will going to ask you this thing that which information should be shared with the other party. So this mediation as an overall process is a confidential process. At the same time, whenever mediation interact with any of the party, at the same time the mediator asks this question that whether you want me to share this information with the other party. So in this way, it gives you an edge. Okay, because whenever you do businesses, there are certain informations which are very confidential in nature. So you want to preserve that confidentiality. So these are certain essentials of your mediation. Now, if we look into the structure of mediation, there are various approaches of mediation. Like, for example, if we are dealing in a commercial dispute, if we are dealing with a family dispute, what approach of mediation you will going to take? So remember this thing that there exist different types of approaches. For most of the disputes, when we are talking about, be it commercial dispute, be it any other category of dispute of like nature, mediator is having a facilitative process. Okay, but when we take the example of your family mediations, there the approach of mediator is not that facilitative. It is an evaluative style of mediation. So remember this thing that when we conduct mediation, depending upon the nature of the dispute, the mediator decides that what approach he's going to use, be it your facilitative mediation, be it a evaluative mediation. At the same time, if you see the different legal systems around the world, you will going to see that the mediation can be broadly classified into two categories. The first category is known as your private mediation, and the other category is known as your court annex mediation. Now, what is the meaning of private mediation is that whenever you enter into a particular contract, you know this thing that this is very common that you put a dispute resolution clause. So you are anticipating the future disputes, and based upon that, you have a very specific clause in your contract which says that whenever in future if a dispute will going to arise, that will going to resolve through mediation. Now, mostly you are referring to a private mediation over there, because you will going to identify that will going to go to this particular type of mediation center, and this would be our mediator. So this is known as private mediation. But certain disputes are there where you might not have a contractual clause of dispute resolution. When you go to litigation and the court thinks that this is a particular case which is suitable for mediation, then the court will going to refer that dispute to mediation. This is known as court annex mediation. So in every jurisdiction around the world, you will going to see the combination that you have private mediation also, you have court annex mediation also. Now, as I have told you about the dispute resolution clause in your contract, so whenever this particular clause is being drafted, remember this thing that there are certain ways to draft this particular clause. Okay, the first and foremost is you will going to see ARB-MED, which is known as arbitration mediation. Second is known as MED-ARB, which is known as mediation arbitration. And the third one is known as arbitration, mediation, arbitration. Now, all these three terms, which I just introduced to you, they are different. Okay, what is the meaning of ARB-MED? Now, the first thing is that you try to do arbitration, okay, and whenever arbitrator think that there is a possibility of resolving this dispute through mediation, then arbitrator will going to halt the process and the mediation will going to be continued. Similarly, you have MED-ARB. The first you try mediation. If mediation is not successful, then you go for arbitration. Then there is a arbitration, mediation, arbitration, which is known as ARB-MED-ARB. First you initiate the arbitration. If arbitration is not successful, then mediation. If mediation is not coming handy in that particular type of dispute, then you can still continue with your arbitration. So these are different types of clauses which you put for your dispute resolution, but by and large, they fall in the category of consensual nature, because what we are concerned with, not with the adversarial process of arbitration, what we are concerned with the process of consensual, which is a collaborative process, which is known as mediation. Now, you must be thinking that where in every jurisdiction around the world, there exists different types of dispute resolution method, why you should go for mediation. Now, there are certain advantages to go for mediation. The first and foremost advantage is this is a cost-effective process. If you will going to compare mediation versus litigation versus arbitration, this is something which is very cost-effective. And why this is a cost-effective process? Because it depends upon the time taken. Mediation generally resolves a dispute within a month, and there are hardly 2 to 3 sessions. But when you will going to compare this mediation with litigation, can we say this thing for surety that a dispute would be resolved in a month? Answer to that is no. And similarly, it goes for arbitration. Arbitration is also a shorter process in compared to litigation, but the fees of arbitrator is very high. So we can safely say this thing that when a dispute is being resolved through mediation, it's a cost-effective process in comparison to your arbitration and litigation. Second is, this is a very speedy mechanism of resolving dispute. Why this is very speedy mechanism? Because if you will going to see the mediation practices around the world, you will going to see that hardly 2 to 3 sessions happen. And in these 3 sessions, in majority of the cases, you will going to see your dispute is resolved. And this is one of the unique point of mediation. As I have explained you that these are the 2 core things that why you choose for mediation, but there are other advantages of mediation also. One of the other important advantages that in your mediation process, you preserve your relationship. How you preserve your relationship? Because whenever you are doing some sort of business with another person, you want to continue that person. But when you go into the litigation, your relationship is not being preserved. But what happens in mediation is that your relationship has been preserved over there. After the dispute also, you can continue doing business with that person. So that's one of the essential, that it preserves your relationship. And the last advantage of mediation is that this is a confidential process, as I have told you earlier also. You are not required to disclose anything to the public at large. So all these advantages make this process an option for you, that why you should go for mediation rather going for arbitration or litigation. So in this particular session, we have discussed about mediation. We have discussed about the components of mediation. We have seen the different styles of mediations, how you put a clause in your contract to resolve your dispute through mediation, and the advantages of mediation. I hope you have learned all these things from this particular session. Thank you.